Hey everyone, it is Mo from Mo in the Deep End, and sometimes you should pay attention. Why did uh why did Mo read this as, Supreme Court? And I definitely thought, "Oh, the Supreme Court just smacked down Judge Gull. This is awesome." But they haven't yet. This is actually a response from the group of lawyers that are representing Richard Allen because his rights to have legal counsel were kind of taken away from him. And if you remember yesterday, I put out some videos, or maybe it was the day before, about basically both the AG and Judge Gull having their response to the Supreme Court, the writ of mandamus, or basically going to the other people going to oh, thank you very much, Ava. Uh, you know, basically, instead of, the attorneys, Baldwin and Rosie or Rossi, going to the Supreme Court or going to the appellate court, they went to the Supreme Court and, our AG and Judge Gull were very upset about that. So this is the response to that. And I think I kind of skimmed through it and I really liked some of the, you know, responses to it. So I'm not going to go over all of it. It is publicly available now. So I do like some of the things that are on this. And I really do like some of the things. So here is a summary. This writ is the only remedy. Any trial without Baldwin and Rossi, Rick's counsel of choice, would be merely for show. Only two lawyers can be ready for a speedy trial and carry out Rick's well developed trial strategy, and only one court can grant that relief. This court. If this action is not taken now, Rick's trial will be delayed longer and even more public resources will be spent. But more importantly, the public's trust in the judiciary will be permanently undermined while the world watches. An appeal is inadequate. Again, there's issues with them having gone to the appeal or the appellate court. Once Judge Gull took them off as lawyers, they really could not go to an appellate court. They had no standing. So it's sort of ticky-tacky language that both the AG and Judge Gull were using. Again, like, "Oh, you're not following protocol." Well, again, if they had followed protocol, they couldn't follow protocol because they couldn't have gone to an appellate court because they no longer had standing. And again, you took away the preferred counsel of, you know, the defendant. They were ready to go to trial, basically. Now, this has a lot of state law, but uh, so this case presents a paradigm situation for a writ of mandamus. Now, let me pull up because as a non-lawyer lawyer, as you know, um, we will look up writ, not wrote. Ta-da! Writ of mandamus is an order that requires respondent to take action, mandamus, to cease action, prohibition, or both. So this is basically telling the court, look, you either need to do this and or stop this. Dang Latin. And no, I don't want you to know my location. But this is basically begging, thank you so much for becoming a member, Tianita. Where the attorneys have been or should have been, this court routinely relies on its own jurisdiction to address claims where attorneys have been or should have been disqualified. And there's a lot of case law that goes with that. And the respondent and attorney general do not dispute this fact. So again, it's everyone is is sort of saying, "Okay, well, this is definitely kinda squirrely, but, it just do we really wanna make a big deal out of this?" The unlawful disqualification of a lawyer strikes at the heart of the public trust in the integrity of the judicial process and requires this court to invoke its inherent authority to supervise the conduct of lower courts. A, the respondent severed attorney client relationship, quote, on her own motion over Rick's objection. So again, she, this judge, there is a process. The entire problem with this is what is the way I see it as a non-legal lawyer is that now they are wanting to go by process when this particular judge didn't follow a process at all when she took away, Richard Allen's attorneys. And so much of this has looked so squirrely from the beginning that it just feeds into this sort of, you know, whether or not there's a grand conspiracy or Odinist or anything else, it just looks shady. But that's just me. Hello, Sal. So the respondent misapplies State XL Jones v. Knox Superior Court 1, lots of numbers. When she argues a writ is inappropriate, in Jones, this court denied a writ of mandamus and prohibition petition that challenged the trial court's decision to disqualify criminal defense counsel in a murder case. There, the attorneys initiated their own withdrawal. This court did not deny the writ for failing to have a clear, unequivocal right to reinstate counsel but because this court, quote, "will not countermand the trial court's ruling that placed defense counsel in precisely the position their motion indicated their willingness to be." So, basically, the court didn't, make the lawyers stay on, I believe is what that's trying to say. This court did not doubt for a moment that a court initiated discharge would properly fall within the court's original jurisdiction. This court is generally of the view that a trial court is limited in its authority to remove a criminal defendant's court-appointed counsel. Here, the respondent has made clear she was discharging attorneys Baldwin and Rossi, quote, "on her own motion, regardless of how defense counsel proceeded or what the prosecutor wanted her to do." Respondent initially suggested defense counsel just, quote, "read between the lines." "Oh, no, you're okay, I started early." Yes, 9 p.m. Eastern Time. No, I started early because this was just hot. This is the response, from so the state attorney general and Judge Gull responded to, at least Richard Allen's sort of motion to the Supreme Court to let his, original defense team come back to his case as they are working pro bono. He wants them back there. He wants them officially reinstated. Judge Gull and the Indiana AG, who is hilariously losing a TikTok case now, because of course he is, basically both sent in responses, that outlined certain things. This is a response to their responses. This outlines where, um, the attorneys for Richard Allen believe that they have either misinterpreted the law or they continue to fight their case to get the defense attorneys back on. And it really does point out, again, how outside of, due process, procedural, any checks and balance that Judge Gull seems to have been regarding what she was saying. Quote, "You're a lawyer. Reading between the lines is what you do for a living." End quote. Eventually, she made it clear that she was unequivocally severing the attorney-client relationship, and there was no situation where attorneys Baldwin and Rossi could proceed with representing Rick. And this is straight from the transcript, so Mr. Rossi. So what you're basically saying is, quote, "You guys either quit on your own accord or make me fire you." Is that what the court? No, I'm saying to you that this is what I plan to say to the court on record when we convene at 2 o'clock. Mr. Rossi. Well, so is the culmination of what you are that you are removing us from the case? The court. I will, based on what I've just shared with you. Mr. Rossi, okay. Well, just want to make sure we're the court. And I'm just giving you the opportunity to have a conversation, which how would you want that to go? I don't want to have to do this. I don't want to do this, but I will if I have to. So again, this is from the transcript where she's basically telling them, I will publicly shame you and call you both negligent and reckless and, basically just terrible at your job. And welcome, Vale Hammer and Cindy Lou Woot, or Cindy Lou Hoot. Look, it's been a long week. I can barely read at this point. The respondent acknowledged that the prosecutor had initially asked to remove the defense counsel during an informal phone call, but she concluded that she did not need a formal hearing on that request or even a pleading on file because she was acting to sever the entire defense team on her own motion. Again, I have asked, you know, several defense people. I mean, other lawyers I know, this has never happened. There are procedures. There are ways you do this. You have a paper trail, you have records. This is not how this is done. Mr. Rossi, I am extremely, I'd say frustrated's probably a soft word with the idea that we showed up today without any real opportunity to prepare for any of this. And I just think it's improper, and that's where I am. That's my position. The court. Well, I think we talked about when you and the prosecutor asked for disqualification, and I indicated on our phone conversation, I'm inclined to do that. Mr. Rossi. It was a phone conversation that was not on the record, and then some follow-up emails. The court. True. Mr. Rossi, there's an informality to that. The court. True. Mr. Rossi, and you also said you hadn't even done any research and you hadn't, had time to talk to your senior judge and all these other things, and the prosecutor hasn't filed a pleading with the court either. The court. No, I'm doing this on my own motion. Again, the 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 court is not supposed to. Okay. There are so many things that the founding fathers so many restraints that the founding fathers originally put on the judiciary because they saw how corrupt judges could really screw with your life. Not so much politicians. Politicians can make the laws, but I mean, honestly, you don't see them much. But, a corrupt judge, a judge that, judges on a two-tier system, and I'm not accusing Judge Gull of doing this at this time. I'm simply saying the founding fathers foresaw that, activist judges or unfair judges, the judiciary was supposed to be very constrained. They were supposed to be a very, you know, constitutionalist, very originalist sort of thing because they had seen how, out of control judges really, really could screw with you. And they didn't want it to happen in this country. Attorneys Rossi and Baldwin offered an alternative to avoid eliminating the entire defense team and to ensure some semblance of continuity of counsel and efficient administration of justice, but the respondent flatly rejected that request. Rossi, is there any scenario where the court would accept if I stayed on the case? I'm a team player. I'm not the kind of guy that just bail out on someone for just the sake of doing it. But I think it's obvious that, Attorney Baldwin can speak differently, but I'm not as connected to some of, this recent circumstance as Baldwin is. Mr. Allen is in a situation where he's going to have counsel that's if it's new counsel, it's going to take them a year to get up to speed with the depth of information that continues to come in. And so I think that his Sixth Amendment rights matter, and I'm probably the one that can at least move this thing forward with some sense of judicial economy. I don't like it, and that's not what I intended to do when I came here today, but it would be kind of the worst case scenario on our side. So, is that an option that the court would entertain? No, the court. Hello, Snivels. Attorneys Rossi and Baldwin spoke privately with Rick and returned to chambers to advise the judge. Rick objected to severing the attorney-client relationship. Quote, he wants us to continue with his representation. Attorneys Rossi and Baldwin suggested the respondent hear this directly from Rick. Mr. Rossi, I think it's appropriate that the court let him speak into the record his thoughts, unless the court just accepts it as notice that these are his opinions. They expressed concerns that Rick's rights against self-incrimination would be prejudiced if he was forced to speak on public record without counsel. They also suggested bringing Rick into chambers. Um, Quote, it seems a little bit of a difficult position to put a man who's been accused but not found guilty, to put him in a courtroom and have him, speak in this circumstance with 15 minutes notice. Quote, I think it's appropriate that the court let him speak into the record. The judge declined to hear from Rick directly because it would make DOC uncomfortable and because, quote, she would not be comfortable having him in her office. Y'all, I can't with this woman. I really, really can't. A, he is supposed to be considered innocent. You are deciding a man's fate. Look, they prove beyond a shadow of a doubt that he did this. Let him go to jail in the darkest corner of Hades. I kid you not. I will be right there, letting him go. But until then, we have a man who has not been charged in isolation at Westfield Correctional Institute. The judge removed attorneys Rossi and Baldwin over their and Rick's objection. B, the respondent had an absolute duty to refrain from severing the attorney-client relationship. Not a single Indiana case has tolerated similar behavior from a trial judge. Yeah, exactly. And the fact that she looks like our current Surgeon General does not help her case. Hello, Digger420. And Kim, thank you so much for the Cash App yesterday. I appreciate it so much. There are only two narrow situations in Indiana where a trial court has jurisdiction to sever attorney-client relationship against the client's wishes. One, the lawyer is not a member of the state bar, and there's a case citation. Or two, the lawyer has an actual conflict of interest that will obstruct his ability to provide effective representation. Another case citation. She is an elected judge. She is currently on sick leave. As far as I know, I don't know if she has been taken off of that. Um, running Helping Nick with the Young Thug trial and doing Newsy News, I get a little, I try to stick up with Newsy News, so I haven't kept tabs on where Judge Gull is. I know you're going to be shocked. And trying to make sure the youngest, most feral memorizes the Bible verse that he's supposed to be memorizing this week. It is like training cats. No Indiana court has ever tolerated a trial judge removing a lawyer from a case over the client's objection, any based on anything other than those 2 reasons. And throughout their 8,000 words and nearly 50 pages of briefing, the responding parties failed to present a single Indiana case tolerating this behavior from a trial judge. Hello, Bobby. Awesome. I would like them to do the laundry and fold it instead of hiding in the piles of warm laundry, which is what I would do if I was a cat, so it's really just jealousy. Every Indiana disqualification case cited by the responding parties involves one of the following: A, or 1, 1, conflict of interest; 2, an unlicensed attorney; or 3, a judge being reversed because she removed a lawyer from a case for some other reason. So they go on to cite all of the cases the that Judge Gull cited and our attorney general, who I didn't vote for, um, you know, they all cited in their responses of, "But you didn't follow proper procedure." Attorneys Rossi and Baldwin are licensed attorneys without any conflict of interest. The judge had an absolute duty to refrain from severing the attorney-client relationship. C. Respondent obstructed attorney-client relationship for reasons totally unconnected to the Sixth Amendment. When respondent severed attorney-client relationship, she was acting on subjective opinions about defense conduct outside the courtroom, not on any Sixth Amendment concerns that might alter the trial's outcome. Respondent argues that attorneys Baldwin and Rossi committed multiple violations of rules of professional conduct and that she acted to, quote, protect, Richard Allen's Sixth Amendment rights to an effective assistance of counsel. The rules of professional conduct are not coexistent with the Sixth Amendment guarantee to assistance of counsel. Apparently, there's a case for that. Ethical standards can apply to a broad range of attorney conduct totally unconnected to the Sixth Amendment. And the Sixth Amendment is concerned with deficient performance that has a reasonable probability to alter a trial's outcome. Attorneys Baldwin and Rossi did not violate any ethical rules, and the judge, if she believed there was a violation of the rules of professional conduct, should have reported the violation in accordance with her obligation under Rules of Judicial Conduct 2.15. But this never occurred despite respondent claiming there was a violation of ethical rules nearly 1 year ago when counsel issued a press release in November 2022 affirming Richard Allen's innocence. So again, there has been just gross kind of flagrancy of due process or any sort of, adherence to typical standards. Again, if Judge Gull felt like they were, you know, flouting ethical rules, she should have cited them, because it is her obligation under her rules of judicial conduct as, trying to be a referee and making sure these lawyers are she's hurting, cats too as a judge. So if she really thought that they were being unethical, like she was whining about in her response, then she has an obligation, according to her code of conduct, to report that. In any event, respondents' subjective concerns about attorney or with attorneys Rossi and Baldwin, who are wholly unrelated to the Sixth Amendment. Respondents' primary ground for her subjective belief about counsel's performance was the evidence leak discovered in October. Yet, Attorney Baldwin was a victim of a crime allegedly committed by Mitch Westerman, who surreptitiously took photographs of evidence. Law enforcement, a prosecutor, and the Johnson Superior Court have reviewed this matter and found probable cause to believe Attorney Baldwin was a victim of a crime. Good evening, HT. What happened to Attorney Baldwin in October and other instances cited by the respondent in no way affected the quality of representation attorneys Baldwin and Rossi provided Rick and did not disrupt their trial strategy. D. Rick clearly and repeatedly asked respondent to refrain from severing the attorney-client relationship, but she acted anyway. Just this woman. Disqualification was first mentioned by the state in a phone conference on October 10th, 2023. The very next day, Rick unequivocally affirmed in writing he still wanted attorneys Baldwin and Rossi to represent him. Trial counsel filed Rick's letter with the court and included a lengthy letter to the court that explained uh, the court lacked jurisdiction to disqualify counsel because there was no conflict of interest. That same day, the trial court ordered counsel to cease working on Rick's case. Before the hearing on October 19th, 2023, Attorney Baldwin retained counsel and filed a memorandum, again informing trial court that it lacked jurisdiction to remove counsel absent a conflict of interest. During an in-chambers proceeding held before a hearing in open court, when respondent revealed that on her own motion she was disqualifying counsel, Attorney Rossi argued that the respondent lacked the authority to do so. After the chambers proceeding, Attorney Rossi filed a notice informing the court he was remaining on the case as Rick's attorney, as well as a motion for the respondent's recusal. The court struck the pleadings and indicated it would take no action on them. Attorney Baldwin, by his counsel, filed a motion to reconsider his removal as counsel, arguing the respondent lacked jurisdiction to disqualify counsel. Particularly considering that the motion for her recusal was pending, respondent didn't take any action on the motion. The day before the next hearing in Rick's case, attorneys Baldwin and Rossi entered their appearance on Rick's behalf as private counsel. At the hearing, Rick's attorneys argued again that the court had no authority to remove them as counsel. On each of the 6 occasions mentioned above, attorneys Baldwin and Rossi informed the court that the respondent lacked the jurisdiction to disqualify them. The claim was clearly and repeatedly presented to the trial court, but the trial court chose not to act contrary to her absolute duty to refrain from severing the attorney-client relationship. This woman is ridiculous. Just ridiculous. E. The respondent delayed an efficient administration of justice. Respondent's conduct in this case was particularly harmful because severing the attorney-client relationship delayed the efficient administration of justice. The Attorney General argues that the need for efficient administration of justice should be balanced against the defendant's Sixth Amendment rights. Indeed, Indiana courts do not require judges to unflinchingly grant continuances or delay proceedings so a defendant can bring in counsel of his choice on the eve of a trial. Trial court balancing a defendant's, quote, right to go to trial in a timely manner with the defendant's desire to delay proceedings indefinitely while he waited for his preferred attorney to recover from a potentially fatal medical condition. That was the case that was cited here. A defendant's last second gamesmanship for a new lawyer caused substantive time loss for jurors, lawyers, and the court. But the opposite situation occurred here. Respondent delayed proceedings to insert counsel of her choice. And therein lies the problem. Judge Gull, if you are new to this case, uh, was picked because the original judge from Carroll County decided to recuse himself because he felt that he was getting threatened either by media or certain other people. So he recused himself. Judge Gull was appointed. She is from Allen County. Now, I have been informed by my friend who is an appellate lawyer that there is uh, a mechanism by which you can pick defense counsel from a pool from the entire state versus your own county. What happened is Judge Gull picked Richard Allen's new defense attorneys from a pool from Allen County. Now, who she picked may on their own be good, defense attorneys. I don't know. But one was just recently getting off a 3-week suspension for God knows what, because that is sealed. But it was a 2 to 1, vote, 2 to reinstate him, 1 to not reinstate him, and, you know, he is allowed back with the, caveat that he doesn't retaliate against anyone. And then the other one, since he was not a lawyer on the Allen case at the moment, when the probable cause affidavit first was made public, he pontificated on the ballistics information and evidence being, crucial and or fairly good evidence. So you have, you know, dude on probation, guy who thinks ballistics evidence is pretty good, which is very contrary to what, Richard Allen's defense that she is trying to yeet is having because they wanted the ballistics evidence thrown out. As you know, ballistics evidence has been, challenged here of late. I think the Maryland Supreme Court was the latest Supreme Court to really challenge this. So it's not as definitive as, forensic files or CSI or that kind of thing led us to believe, or I naively believed. I won't put us all in there. Maybe you guys were smarter than me, but I definitely thought that it was, like 100% like a fingerprint. I had no idea that it was a bit like, meh, you know, 70-30, 60-40, something like that. When the judge severed attorney-client relationship in October, trial scheduled to begin January 8th, 2024, Rossi and Baldwin spent nearly a year reviewing the voluminous discovery, conducting depositions, developing a speedy trial strategy, and pursuing defense of third-party guilt. So, hello, bad weather biker. So, and ghostery. Yes, I did start a little early, but this is I'm going through the response. Basically, the lawyers who on behalf of Richard Allen are presented to the Supreme Court uh a writ of mandamus, so basically begging the Supreme Court to say, "Hey, the fact that the lower court took off Allen's original defense was way wrong." This is their response to Judge Gull and the AG's blathering. I'm sure they didn't label it blathering, but I did. let's Attorneys Baldwin and Rossi were active members of and in good standing with the Indiana bar, and they told the judge they were ready to, quote, try this case in January. There is nothing in the record suggesting otherwise. The judge, on the other hand, had not ruled on several of Rick's substantive motions. The Frank memo, which sought to suppress the warrant search that uncovered a firearm, has been pending since September 18th, 2023. So again, this judge seems to have had no desire to really rule on any of the defense motions. As of October 31st, 2023, respondent had not finished reading the motion. Quote, I haven't even reading it. I haven't finished even reading it. The motion for the state to produce Rule 404 and 405 evidence, which would inform counsel's decision whether to put Rick on the stand, had been pending for nearly a year. So again, this is, you need to turn over discovery. For the love of God, you have to actually turn over discovery. And, the judge was like, in a minute, in a minute, I'll get to it when I get to it. Also pending is an August 2023 request for the transcript of the June 15th hearing, which counsel needed to use as at a deposition and hearing. Finally, a motion in limine on ballistics evidence has been pending since June 13th, 2023. What the actual hell has this judge been doing? The motion seeks to exclude purported expert testimony that an unspent cartridge found near the crime scene had been cycled through a gun found in Rick's home. A ruling from this motion is obviously critical to, quote, "It- the efficient administration of justice." When the respondent severed the attorney client relationship, she was not balancing the Sixth Amendment right against the efficient administration of justice. On the contrary, she violated the Sixth Amendment when she inserted counsel of her choice and delayed all proceedings, denying Rick, the victims, the witnesses, and the public the efficient administration of justice. So it really is. I mean, there is something rotten in Denmark here. F, the remedy on this appeal is non-existent. Only an original action can achieve a speedy trial with attorneys Rossi and Baldwin at the helm. Rick is a pre-trial detainee who is over 50 years old, has deteriorating health, and is housed in a prison among individuals who have been convicted of crimes. He files this writ asking for attorneys Rossi and Baldwin to be reinstated, to remove the trial judge, and to mandate a trial within criminal rule timeframe. So basically, to have a speedy trial. Only this court can deliver that relief. The responding parties fail to address the interwoven connection between Rick's speedy trial request and the respondent's Sixth Amendment violation. Here, murder trial charges were filed on October 28th, 2022. The parties agreed to set this case for trial on January 8th, 2024, which is outside the criminal rule period. Rick had a right to assume the trial would be held on that date. Rossi and Baldwin spent nearly a year reviewing the voluminous discovery, conducting depositions, developing a speedy trial strategy, and pursuing the third party, guilty defense. So basically, someone else done did it defense. So they would be ready for trial on January 8th. Attorneys Baldwin and Rossi were ready to try this case as scheduled. Respondent severed the attorney-client relationship over Rick's objection and thrust new attorneys upon him who were unprepared for a 3-week trial, scheduled to commence in 3 months on January 8th, 2024. No attorney coming into this case could be ready for a trial of this complexity within that time frame. Only attorneys who have worked on this case for over a year could be prepared. In short, only attorneys Baldwin and Rossi can be ready for a trial within the limits of Criminal Rule 4. A direct appeal after a jury trial is wholly inadequate. Trial has already been continued at the request of the new public defenders by 10 months to October 2024, and the trial may very well be continued again. When trial eventually proceeds, there will be an unresolved Sixth Amendment issue. Carroll County, Allen County, the witnesses, the victims' families, lawyers, and Rick will be dragged through a constitutionally infirm trial. The Sixth Amendment issue will permeate every aspect of this case, rendering a fair trial impossible and a tremendous waste of resources. The trial will be for practice only. Furthermore, the remedy on appeal will be a retrial. Not retrial with attorneys Baldwin and Rossi. Richard Allen wants a trial with attorneys Baldwin and Rossi, and only this court can grant that relief. Even if Richard Allen is acquitted at the trial in October 2024 or months thereafter, his rights will still be violated because justice will have been long delayed while his 50-year-old health continues to deteriorate in prison. Quote, justice too long delayed is justice denied. An interlocutory appeal would only exacerbate the harm Rick has already suffered. Even under the best circumstances, an interlocutory appeal takes months before a decision is reached, assuming one can receive permission from both trial court and the Court of Appeals. We must remember that reversals are but palliatives. The cure lies with those remedies or those remedial measures that will prevent the prejudice at its inception. So basically, what they are saying is that, hey, dum-dums, attorney general and judge, yes, first of all, if he gets convicted and he wants to appeal this, he will win on Sixth Amendment, rights, and it will be a retrial, and then the state of Indiana will have to pay more. And if you want to go with an interlocutory, you know, appeal, that is a huge waste of time, and again, it should why waste time with that when you have a simple answer here? Given the respondent's comment regarding trial counsel's performance and credibility, she cannot oversee a trial where they represent Rick. A judge shall be disqualified in any proceeding in which her impartiality might be reasonably questioned. Indiana Judicial Conduct Rule 211. Respondent argues that neither Rick nor attorneys Baldwin and Rossi demonstrated that the respondent had any bias or prejudice toward them. Yet, even before circumstances surrounding the discovery leak had been fully investigated, respondent indicated that she was leaning toward disqualifying counsel. Respondent also claimed counsel's motion for immediate transfer of custody for Rick had, quote, a lot of inaccuracies, quote, or end quote, when compared to the state's affidavits. Respondent indicated she was denying the motion, even though no hearing on the motion had taken place and Rick had been given no opportunity to present evidence. The respondent said the same thing about Rick's motion requesting a modification of the safekeeping order filed back in April 2023, that it contained inaccuracies and falsehoods. Respondent based that on the state's evidence presented at a hearing on the motion, but failed to acknowledge that the respondent relieved the sheriff of his burden to transport Rick's primary witness to the hearing so that he could testify in support of Rick's motion. So basically, he told the sheriff, "Hey, you don't need to bring Rick's witness. We don't need him. It'll be okay." Major Lesenby was advised by the court to disregard any further efforts to retrieve inmate Baston from Westville Correctional Facility. What in the absolute boss hog, Dukes of Hazzard corruption o'clock is this crap? Conclusion. The court This court is the only court now that can ensure Rick receives his fundamental right to counsel. A writ of mandamus is appropriate to reinstate attorneys Baldwin and Rossi as court-appointed counsel, to set a trial date within 70 days from the issuance of a writ, and to remove the special judge and appoint a new one. Maybe a less special judge? Special, if you know what I'm saying. But there you have it. I believe that that was chef's kiss smackdown of both Judge Gull and our ridiculous AG. But let's get into some news. Some newsy news, because that's why you guys are here. Our first newsy news story is that the owner of Mid-Michigan Dam that collapsed and sent thousands fleeing is found liable for $119 million in damages. Well, again, if you built the dam wrong, I really don't have a problem with that, but let's read. A gazillion. A bajillion gazillion, because I try to pull a bunch of stories because I never know what I'm actually gonna pick until I actually pick them. I have all the ADHD. I have all of it. The previous owner of the Mid-Michigan Dam that collapsed before flooding the city of Midland has been found liable for more than $119 million in damages. Uh, a federal judge issued a default judgment against Lee Mueller, whose company Boyce Hydro owned the Edenville Dam when it was breached by extreme floodwaters that forced the evacuation of more than 10,000 people in 2020. In his ruling, Judge Paul Maloney said that the state was entitled to about $119 million, uh, and that Mueller was liable, which includes tens of millions of dollars in damages to the state's fisheries and freshwater mussel ecosystem. The judgment comes months after it was determined that both Mueller and his company were responsible for the flood. He has since declared bankruptcy. Dana Nessel has pursued relief in the years since the disaster on behalf of both the Department of the Environment, Great Lakes and Energy, as well as the Department of Natural Resources. Quote, "The dam's ownership completely disregarded imminent threats to safety and integrity of the dam. And as the state clearly demonstrated before the court, Lee Mueller and his business were responsible for the disaster that struck Edensville and other area communities," the state attorney general said. Quote, "This nearly $120 million judgment is important both as a measure of accountability to the community Mueller devastated and as a deterrent to other owners of critical infrastructure." Well, I mean, he's broke, so good luck. Unless it was an LLC. Well, I mean, if it was an LLC, then you're not getting any of his stuff, but maybe he has a bunch of Beanie Babies that are worth he's got the Princess Diana one. That one's special. EGLE Director Phil Roos called the impact from both the Edensville and Sanford dams, quote, "avoidable." Quote, "The courts have rightly declared that the owners of critical infrastructure must not put their own interests ahead of the safety of Michiganders, our environment, or our natural resources. EGLE remains committed to supporting the community through permitting replacement structures as it builds. Ah, well, there we go. Hydroelectricity for everyone. Okay, Digger 420, we'll try it, but I don't know how I feel about bagged milk. I'm not sure. Uh, in other news, a Kia owner fed up with multiple thefts dumps his car back at a dealership. This poor man. Federal Way, Washington, one Kia owner got so fed up after his car was stolen that he decided to dump the vehicle off at the dealership where he bought it and walk 4 hours back home. On Monday, oh Lord, Behruz Almirati said someone stole his Kia. The incident happened in Federal Way. The gentleman said the police found the car, but as it sat parked in the driveway, he said someone came back and smashed out all the windows. Quote, "I'm tired, you know. I swear I'm tired about this car," he said. The gentleman said that in 2 years, he's dealt with four different incidents involving this car. He's paid thousands of dollars out of his own pocket to get the vehicle repaired, but this most recent incident was the last straw. "This situation is too much bad. I don't want it," he said. The gentleman said he was so upset with the situation that he dropped his Kia off at the dealership and walked about 4 hours back home. Fox 13 News spoke with the dealership. An employee told us they can't legally comment on the situation. Law enforcement continue to warn Kia and Hyundai, or is it Hyundai? It's Hyundai owners to protect themselves because their cars are being targeted by thieves. In a 2022, videos popped up on social media demonstrating the process of how to take without asking these kind of cars. The how-to videos led to a trend of car thefts, and the criminals were dubbed the Kia Boys with a Z, so you know they're extra cool. Recent violent crimes in Tacoma have involved stolen Kias. Tacoma police reported on Sunday night around 10 p.m. about 5 to 8 suspects, described as young looking, wearing ski masks, driving a stolen Kia, held someone up at Force Multiplier Point and stole their car. Police pursued the suspects, but investigators say the thieves ditched the stolen cars and took off running into the woods. There are canines. Look, I'm about done with people. Okay, so Kia and Hyundais, I believe, have look, I haven't looked at the YouTube videos. I am dead awful at technology, but there is supposed to be some sort of glitch that makes them especially easy to steal. Um, so there has been a just epidemic of people, okay, what we would loosely term Utes stealing Kias. So there was a documentary called The Kia Boys. I believe that was in, I wanna say Detroit, but I'm not quite sure, at least the documentary. So, there's something there's some sort of glitch that makes it very easy to steal one of these cars, but, so I guess this guy was like, "Look, I is done. It's already done been stolen, like, twice." Then, as it was out in my driveway, someone, broke all the windows. I'm out. He was like, "I'm either gonna go full Michael Douglas falling down, or I'm gonna walk 4 hours home," and he chose correctly, he walked 4 hours home. So, there is that. You know what? We need to take a good look at ourselves, and we should all be outraged. And look, I am all for helping legitimate people who are scared to be in their own country because they, you know, maybe they're, in an Islamic country and they're gay, or maybe they're in, you know, or they're Christian, or they legitimately have spoken out against their government and they are afraid. But these asylum seekers who have gone through other safe countries and then this army vet is being kicked out, we'll read. But this legitimately pissed me off. Look, I want people to be able to come to America. It's a great place. If you work hard, you can, you know, for the most part, usually, if you work hard, you can have nice things, you can have your own sorts of freedom, and that's really a good thing that we all want. But this unchecked ridiculousness is just it's not good for anyone. Army vet 94 kicked out of New York City nursing home to make room for migrants. Y'all, if this doesn't make you just want to just about, you know, bust out the Team America theme music and, you know, start talking to your local senators and then voting out your local senators, I don't know what will. A 94-year-old U.S. Army veteran is blasting his Staten Island assisted living home for kicking him out to make room for migrants, saying, quote, "It's not fair that he was sent packing." Frank Tamaro was given less than 2 months' notice that he and 53 other seniors would have to move out of Island Shore residences in March to make other living arrangements. This is ghostery. I don't know. I'm I'm reporting the story. Now the New York Post is doing the journalisms. Once I get as big as Tim Pool, I can have my own journalisms, people. I felt horrible. Tamaro, a lifelong New Yorker, told Fox News. Again, there might be a slant on this. I don't know. It's no joke getting thrown out of a home. He then moved to another facility, but after he fell, he and his daughter, Barbara, oh, Anuzinata, decided it would be best for him to move in with her and her children. It was in her care that the family discovered that Island Shores was being converted into migrant housing and would not reopen as another assisted living facility as they were promised. I don't understand it at all, his daughter said. It's not fair to anyone. So again, it's just look, we have a lot of people in this country who are hurting. A huge grain of salt, and Fox News is Fox News, and, let's see. Let me see. Okay. Well, I'm trying to see if there's something beyond or a response because huh. Okay, I'll have to look more into this because I wanna be sure before I say anything else, but I will say that if this is true that they were told that, this was gonna be under new management, you know, again, we're hearing a lot of stories about, you know, homeless shelters and things like that where I don't wanna make it an us versus them thing, but again, native New Yorkers and things like that. Yeah, it does sound like the nursing home was shut down and they were told that it was going to be turned into or taken over by different management into a different, you know, assisted living home, and it turned into, it was going to actually be or maybe plans changed and it was then changed into migrant home or migrant housing, and it might have been that, the migrant housing was more of an exigent need than, assisted living. I don't know. But, you know, eh, that is it too. I mean, I think there's a point at which, there's only so much to go around. That might be what happened, but if you are looking on the outside and you're told you have to leave a place that you have grown comfortable in, and you don't see all of the behind the scenes kind of finagling, and then you hear that it changes to migrant housing, I could see how he would see it through that lens, if that makes sense. But again, we have Americans here at home who need a lot of help too, and I don't mind helping other people, but it it's like with the airplanes, you have to put your own mask on first and then help other people. It's like when you're a mom, you can't let yourself get so run down that you can't take care of other people. It's the same thing. I look, if wishes were horses, none of us would walk. I wish we could help every single person in the entire world not have a craptastic life. But that's not something we can realistically do. So maybe let's, you know, have some real uncomfortable conversations and get some things going. But we have morons as leaders. In the oddest theft I have ever heard in my entire life, serial shrubbery thief busted with 800 or $8,000 in stolen greenery. Serial bush thief. Y'all, I have never heard of rampant greenery theft in my entire life, but apparently this happens, and let me take the banner down. Doo-doo. Y'all, they wrote it, I didn't. I had it bushed though. 'Cause I'm 5.5. A serial shrubbery thief who had been targeting a renowned Orange County nursery has finally been arrested, authorities announced. I y y'all, I okay, to be fair, Mr. Mo would probably do this. I could care less. I tend to kill all green things around me. Over the last several months, surveillance cameras at a beloved Newport Beach nursery, Rogers Garden, captured a thief sneaking into the botanical haven at night and making off with thousands of dollars of merchandise. Quote, the suspect brazenly took prized bushes, carefully snatching exotic plants, and even making off with an entire bench, leaving the business in disarray, according to the news release from Newport. One second, Friberto wants in. Okie dokie, let me get his camera set up because he was playing with the boys and didn't wanna Fryberto? No. Oh, I guess he can have the toy. I hope not. We're not quite sure. We don't know what he is considering he's a Mutski, but, considering he's now started to try to dominate Thor, we may be discussing ye olde neutering soon because we don't want some mutant cat dogs, catlets. Okay, I wanna see this shrubbery thief. They don't show the NBPD detectives worked the case and learned that the unidentified Irving man had a passion for garden decor, decorating his backyard with the nicked greenery from the nursery, including the trees, plants, and pots. Well, sir, if you would like to crime, maybe don't put your thievery out in the public. Well, there you go. Well, Thor, you're you're just going to have to get used to a little bit of attempted domination. The man is facing charges of grand theft, authorities said. Well, God bless the fact it was over $8,000 because if it had been under $1,000, they'd have just let him be. And what the hell is wrong with this woman? We have this woman who seems very attractive until you start reading, the words coming out of her mouth. I know, I love that. Mom charging family $200 per Christmas dinner. Everything I do is for profit. Ma'am, you is cute, but not that cute. I think you are, like you would have to be, I don't know, Angelina Jolie or Megan Fox, like you'd have to be sex on a stick, like 10 to the power of 20 attractive. $200 for a Christmas dinner? I'd be like, "I'll see you later, I'll make my own damn dinner." A mother dubbed, quote, "Britain's most hated woman" is back in the spotlight, this time for charging her family members to dine with her on Christmas dinner. On second thought, if I charge my family no, I'm just kidding. What is wrong with you? Carla Bellucci said she is charging her relatives nearly $200 per person for family Christmas dinner, believing that she should be compensated for the burden of preparing a meal for 15 people. Ma'am, all right, we're going to have to get out the whiteboard of truth. I didn't want to have to do this because I'm lazy, but seems that we need to explain right some things. Okay, this is you. Now, oh crap, you can't see purple. You can't see pink very well. All right, ma'am. Now, Fry, there is no food. Look, Snarfles. All right, ma'am, this is you. Now, Christmas is about doing things for not you. Now, I know this is confusing because In your brain, which I'm sure is about we're gonna go ahead and give you maybe a quarter we're gonna go walnut size. This is all consumed with you. But see, Christmas is actually about well, okay, it's actually about the Catholic Church stealing the heathens, you know, holiday and making it a little bit more palatable. But pretend it's about Jeebus. His name is Jesus. Now there's this book. It's called the Bible or the Bible. Now, it's going to explainarate to you. Now, look, as the world's not best Christian, I'm a little too much into, flipping tables and such. But see, this baby did all this stuff and he kind of went on this cross thing and he did a bunch of selfless shit. So, see, this is all about not you again. So, when the circus music in your head that's going me, 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 yeah, no, Christmas is supposed to be the one time you put that shit on stop and you do things for others because in theory, you are celebrating the fake birthday of Jesus. Okay? Jesus did selfless shit. And taking care of your family is something you do because you love them, not because you get paid. Lord Almighty, if I got paid for what I did around here, but I do it because I'm a mom and that's my job because I care for my family. And I also don't want to get, placed on hoarders. But again, you're a mom, you're a wife, you're a family. This is about Jesus's fake birthday. It's not supposed to be about you. That has been the whiteboard of truth. For the love of God. Let's see how she continues this wonderful idea of ridiculous. It's not cheap feeding people. It also takes a lot of time to put a meal together. This woman does not cook. This woman probably makes ramen damn noodles and calls it a damn meal. Change my mind. This woman hasn't seen a stove or cookware in 15 minutes. Change my mind. The 42-year-old told the Daily Mail, and she won't take any criticism, telling those that disagree, get stuffed with all the trimmings. Bellucci has an immediate family of 6, including her husband, Gio, and her 3 youngest children, Tanisha, 18 I'm not gonna talk about the kids' names, and is expecting 9 additional relatives at her home Christmas Day, most of whom are expected to pay upfront at the door. Well, again, it's part of giving. I understand that this is a foreign concept, but see, you give of yourself. Now, ma'am, think of doing something nice for yourself, but when you're gonna give that thing to yourself, you turn it around and reverse Uno card it to someone else. It's a strange feeling, and you'll feel a little weird at first when you're doing it, but once you get used to it, you'll really get you are not hot enough to be this self-absorbed, okay, ma'am? I'm just telling you the truth. You are not like Cindy Crawford, you know, Pepsi 1991 mom jeans, but she made them look hot. So you cannot do this. I mean, you're very attractive, but you are not hot enough to deal with. You are no. No, I think she just sh wait till we go on. It gets worse. The $20 or the $200 fees includes a complete turkey or a complete dinner starring turkey, 1 glass of champagne, any additional alcohol consumed will have to be bring your own bottle. The absolute tight-fistedness here. She admitted she will be pocketing at least some of the money from the holiday feast. Y'all are getting spam. Y'all are getting spam and some hot pockets, and you know you are. You know this woman does not know how to cook. But some of the relatives might be disgusted by the idea and not bother to show, Bellucci said. But, quote, if you want quality, you have to pay for it, ma'am. Quote, you might find a carvery that's cheaper than my place, but my dinner is going to be a lot more classy than that. Full on dumpster defender voice. I doubt it. It wouldn't be any cheaper if you went to a restaurant or a hotel for Christmas Day meal, so why should I be out of pocket? You really have no idea. Her guests will be treated to listening to King Charles make his Christmas speech since the television will be on. Well, there you go. Which Belushi apparently qualifies as a dinner perk. A strict schedule will also be enforced, said Bellucci. Stores will open at 2 p.m. After a game of charades, she intends to kick them all out and send them home at 10 p.m. Of course, this isn't the first time Britain's most hated woman wasn't so generous with her children on Christmas. In 2020, the mom of four bragged that she blew $10,000 on Botox and veneers instead of buying her kids Christmas presents. Snake Island. Look, all right, nope. I didn't want to have to do this, but we are taking look, I don't have an official all right. I am taking the unofficial cranberry wine bottle of excommunication, but you are officially excommunicated as a mom, as a lady, and you are now just a female. You are out of the church of sisterhood, out of the church of moms, out of the church of ladies. You are now just a female, and F you, ma'am. I'm gonna have to get my own, anti-holy water excommunicator, because we got a lot of these females walking around. I'm gonna have to excommunicate from the sisterhood. Bellucci first made headlines in 2019 when she sparked outrage after admitting she faked depression to get a nose job with taxpayer money through the UK's publicly funded National Health Service. She then became an OnlyFans model but quit in 2022, claiming it became too tacky for her. Yeah, okay. And ma'am, I can tell you photoshopped this. And even as a person who's not graphically inclined, that line is way there's something wrong with that line. So, ma'am, I can tell you photoshopped it, okay? I'm just saying. In an essay for The Sun earlier this year, Bellucci confessed that she was hiring male strippers to perform at her teen daughter's birthday party. The mom spent more than $700 for strippers who were to serve food with only an apron covering their modesty. Y'all, Snake Island for this female impersonator, and I don't mean that as a dig on drag queens, I mean this as a dig on her. And ma'am, you again, for the 90 bajillionth time, you are not hot enough for your attitude, and one day someone is going to tell you that to your face. And I hope I am there with a camera to see it, because that would be hilarious to see the face that you make, because it'll be hilarious. In our final story, we have all of your burning smexy questions answered by smexiologist, because I am not one. But here you go from Yahoo Life, your burning holiday smexy questions answered by a smexologist. Whether you celebrate Hanukkah, Kwanzaa, Christmas, Festivus, or none of the above, the last month of the year is usually festive and fun, but is it frisky? Thank you, bad weather biker. Are people having more smexy time around holidays because of the abundance of mistletoe, or does spending 4 nights sleeping on Aunt Sally's pull-out couch make for a chaste winter break? And what about that couch? Is it rude to have smexy time in someone's guest room? We called on two prominent sexologists to respond to commonly asked questions about holiday hookups, breakup, and smexy etiquette to find out. Do holiday parties lead to more random hookups? This this seems like a dumb question. This seems like a gada question, but the answer. Blame the eggnog. Sexologist Michelle Hope, aka MHS Sexpert or MH Sexpert calls holiday parties quote a cocktail of nostalgia, mistletoe, magic, and well, actual cocktails that can lead to more festive flings, end quote. This is especially true at office parties. One survey by Harris Interactive found that 25% of Americans say they have had a smexy relationship initiated at a office party. Sexy soirees with alcohol can have a downside, however, as Hope notes, quote, alcohol is a social lubricant, but it shouldn't grease the wheels of decision making. Look, half of the population would not be here if we followed that advice. But she does make an important point. The CDC warns that booze can blur the lines of consent for both men and women. Though I hate it when both parties are drunk and only the female, you know, is said to have been, uh, you know, taken advantage of when the male was just as intoxicated. So, yeah. Flirting is great, but if either of you might be too drunk to say yes, swap numbers for another day. What about breakups? Are there more of those during the holiday? During fall and winter? Again, this is a duh. We're gonna go straight to, is it rude to have, smexy time in your Aunt Edith's guest room? Because I think that's hilarious. Okay, if you're sleeping over at a relative's house, staying in your significant other's childhood bedroom, or having overnight guests in your home, most etiquette experts agree it is okay to do the beast with two backs, but with a few caveats. Let's see. I'm going to guess no golden showers, but I could be wrong. Be respectful by using a safe word. No, I'm just kidding. By keeping it quiet so others don't hear you, and if you're a guest in someone else's home, be considerate and wash the sheets before you leave. As Hope says, if you're known for your vocal performances, if there are squeaky wooden floors, would not recommend. Maybe it's time to hit mute and let actions speak louder than no. I'm gonna let you gauge your house's structural, finesse, and you may know if you could get away with doing things in your childhood room, and if you could not. But if you have squeaky floors, you know, save it for home. Remember, thin walls aren't just a structural issue, they are a privacy nightmare. Yeah, this article isn't as fun as I thought it would be. Oh, wait. Do Smexy toys make good stocking stuffers? Well, maybe not for your mom, but maybe for grandma. You never know. She does read all those Smexy books. I'm just saying. Wink, wink. Both of them agree that a bullet massager or magic wand could be a welcome gift for certain people on your list. Uh, in other words, don't let them open it on Christmas morning in front of the relatives. Oh my gosh, can you imagine that? Like, "Here, bro, here is your C ring. I thought you'd enjoy it." "No, grandma, it's not a real flashlight. No, I promise." Uh, you can also give a toy to a partner, but be careful about the message it sends. Uh, well, there you go. Speaking of toys, is it true people are using Christmas ornaments as Smexy time toys? I have I must see the ER visits for that. In fact, I need all of the ER medical notes if Christmas ornaments were ever used. I need those. I hope not. Those things are sharp and they break and they're full of germs. Oh, dear God. No, 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 not Rudolph. What happened to his nose? It used to be red. Oh my God. What happened to the dancing Santa? We can't find him. We used to have a wiggly arm Santa. Now it's all gone. Oh my gosh. No, this is just terrible. I can't. Not, nope. So that is the newsy news. It was a bit longer tonight, but we did get through the response from the attorneys representing Richard Allen. And I think that they really went through all of the points that, well, especially the new Target Santa that has the wheelchair. It's gonna be a hard one to remove. This nativity had a Jesus, and I want it back right now, no questions asked. You have no idea how many times I have said that in my house, not for this reason, but I swear to goodness, y'all, in the 6 months between when all of the children move out, theoretically, if it actually happens, and the grandbabies come here and I get to spoil all of them and have fun, I want a really nice nativity set. That's all I want. I will have a very nice display. Even if it's in the middle of the 4th of effing July, I will have one nice month of a nativity set, and then I will lovingly pack it in bubble wrap and never take it out again, but I swear to goodness, once in my life, I will have a nativity set where Jesus doesn't get decapitated, Mary doesn't end up running off with a Power Ranger, and Joseph doesn't end up, in a fight with Godzilla. I just won't. I just will. Is one day. One day, it will happen. I will know I have made it to actual adulthood. Like I said, I only need, like, 6 months, and then I will put it all away, and I'll get ready to enjoy grandbabies and grandbaby chaos. I'll still have Fry, so it will obviously have to be high up. I will still have the cats, so obviously it will have to be force fielded. I know. I know it's a giant ask. I will probably have to put it in an upside down. One of the Joseph characters in one of the mini nativity sets I have tried to have. Look, one of the characters always gets beheaded. The baby Jesus gets put God knows where, and I do mean that literally, God knows where. Mary usually ends up running off with one of the Power Rangers, and, we just can't find any of the angels or wise men by the time Christmas comes, and the elf on the shelf is ending up in, the manger. It's a hot mess. So, just once in my adulthood, going to have a nice nativity set. It will probably be in an upside down, fish tank for, safety from Fry and the cats. I will have it in a display, and then I will put it away because grandchildren chaos is awesome and should be celebrated. But for those 6 months, I will have it. So there you have it. We went through the response to the AG and Judge Gull and, basically stating why the Supreme Court is the only court that can take care of, you know, basically the kind of injustice that Richard Allen, guilty or not, he is still considered innocent right now. And what is happening in his case is not right. We went through, let's see, the dam owner has been found responsible. If you have a Kia, I don't recommend just dropping it back off at the dealership, but, keep a close eye on it. They definitely are more prone to being stolen, unfortunately. I will have to do more checking on this story because I do feel like it has a little bit of a slant, but this story does make me upset. Again, I feel like we really do need to take care of our internal problems before we try to help with external problems, but I am just a redhead on the internet. I don't have all the answers, so, you know, um, apparently, the guy with the really good garden in the back was apparently thieving all of his garden stuff. So, he might have had a green thumb and light fingers. And then this woman is not hot enough for the crank attitude that she has, and one day she is gonna run face first into reality, and that new nose is gonna get messed up by reality, not by any person, but by reality. Because my guess is her kids are gonna skedoodle right on out of her life if she continues her selfish behavior. But that's just my opinion. I could be wrong. This has been Nightly Newsy News and the Judge Gull Smackdown, along with the AG. I hope you have enjoyed it, and I will see you in the morning for Friday. It is Friday. We have made it. It is officially December. I have no idea where our elves on the shelves are. My kids will ask. I'll just say that they're still at the North Pole because F if I know where they are in my damn house. Gotta love those Pinterest moms who have, like, frickin' frackin' 20,000 different activities and all these things that they post on Facebook, and you're like, I you just wanna throw the elf across the room, and you're like, "Fuck it." Elves on the shelf are I call them. Look, they're narcs. Like, do we really want Santa narcs? No. Santa narcs. We should not be promoting Santa narcs. Snitches get stitches, okay? We should make kids understand the code of the streets. Any hoozle, I will let you guys go. I am going to get ready for, Megan Fox's dependency hearing. I have a wig to put on because we are going to be well, I am going to be becoming one of these hateful creatures that tried to take Maya away because they're just hateful. So I will see you guys in a little bit. Bye, guys.